Me again. Okay, so we are going to do a, I think many or all of you did the Choices 101 intro. We're not going to cover all ground. I may remind a few things, but this is going to be a much deeper dive into choices, eligibility, and appeals. First, I'm going to cover the PAE process. And Shelby's going to cover all of the math stuff, the figuring out income and resources and community spouses and all of that. So first, without further sample.
Chris broke it.
Okay, just as a reminder, you have to meet both the medical criteria and the financial criteria, the categorical criteria, as we're going to call it. It is based on the level of care, Acuity Scale that TennCare has created, and it's based on how you perform activities of daily living or need for skilled services. Choices Group 1 is for nursing facility care. Group 2 is the full array of home and community-based services up to the cost of the nursing facility. Choices Group 3 is the at-risk for placement in a nursing facility. It's $15,000 cap on services per year, and you have to have SSI to get it. And just a quick background on where that comes from. When Choices Group 1 and Choices Group 2, it used to be just nursing facility care, home and community-based services. And the way you became eligible for that is if you had at least one significant deficiency with an activity of daily living, you could be eligible for program, assuming financial eligibility. That was your physical criteria. Didn't mean you got a lot, so you still had the question of how much services you were going to get on the program. Well, with both first the ARA, the stimulus in 2008, and then in the Affordable Care Act, there was a maintenance of eligibility requirement, which states were not allowed to lower their eligibility thresholds, or I mean, to raise their eligibility thresholds, make any changes to make it more difficult to qualify. TennCare really wanted to use this new acuity scale that we'll talk about. But it's much harder to qualify for choices with that new acuity scale. And we said, you can't do that. A coalition of people, different groups came together and said, you can't do that. There's a maintenance of eligibility requirement. And they said, oh, no. We're also going to do Choices Group 3. And that has the same eligibility requirements as the old system. But it's going to be capped at $15,000. So this was how they avoided the maintenance of eligibility requirement, implemented a new system, and as soon as that maintenance of eligibility requirement ran out, they closed it to everybody except SSI recipients, because the way it was really being used is for people who were in the coverage gap, who we could make the argument they needed some help with their activities of daily living. We could get them on Choices Group 3, and therefore get them TennCare through that. Since SSI already comes with TennCare, this forecloses the opportunity for people in the coverage gap who might need some, but not a whole lot of assistance with their ADLs. They can't use Choices Group 3 as a mechanism to get TennCare anymore. So we're looking at PAEs, this level of care. The PAE is the pre-admission evaluation, and it's where they apply this level of care criteria to see what someone's acuity score is going to be. There are functional measures, so transfer, mobility, eating, toileting, incontinence care, catheter ostomy, receptive communication, self-administration of meds, and behavior. And then there are lots of skilled services that can also get you points. And all this is about the point system. You're trying to get a 9. Everybody's goal is to get a 9. So how do we do this? When you're looking at these functional measures, there are 4 answers to the question. It's always, the applicant is always capable of completing these independently. Though on a few of them,
Behavior.
it's behavior that it flips.
Yes.
So if they're always capable of completing the functional measure independently, usually it means 1 to 3 days a week they need assistance. Usually not is 4 to 6 days a week they need assistance, and never is 7 days a week. So it's usually and usually not. Exactly how many days do you need help? That's often where the rubber really meets the road on what people's score is going to be. Do they get usually or usually not? Always and never is much easier case to make. And just to give you a sense of what this looks like, this is the actual QIT scale. And it's not just points per single ADL, but these groups of things. So you've got your transfer and mobility. You're only going to get the highest value of 2 different possible measures. Toileting, incontinence care, ostomy care, the highest of the 3 possible scores. So you see how that works. It's not a simple scale. It looks much more objective that way, right? And then all of the skilled services. So you don't get anything for having to teach skilled services, but you can get 1 point for some other things. We have asked in the past, because this looks very objective and scientific, and we asked what is the research basis? What's all of the evidence for why you've implemented this QIT scale? Surely you didn't just make it up, did you? The answer was the people who designed this had over 700 years combined experience. So that's where this comes from, is 700 years of combined experience, and no evidentiary basis other than that, apparently. So no other state uses this. This is unique to Tennessee. So now for a little deeper dive, looking, okay, what are they actually looking at when they're assessing people's ability to complete these ADLs? So first on transfer and mobility. Transfer only, first of all, it only considers the ability to transfer from bed, chair, or toilet. There's only 3 things that matter. Do you need help to do this, or from another person? These are the questions they ask. Do you need help transferring from bed, chair, to toilet? Does it need to be another person, as opposed to, say, a bar, a grab bar, or something like that? The question that they're ultimately should be looking at, what people who are applying need to know, is behind every question they should imagine, do you have the ability to do this by yourself safely? And the answer to the question should always be, well, I can do it by myself, but I'll fall down. I think there's a real tendency for people to not want to admit their infirmities, their frailties. So they want to say, yeah, I can mostly do that. It may be really dangerous. I could break a hip doing it, but I can do it. So emphasizing to people, if you do get the chance to talk to them before they do a PA, saying, today's not the day to be a hero. Don't try to show off. We want a real picture of what your needs are. And always remember, can you do this safely? Not can you do it?
And also, that's important for people who are aging solo or live alone and don't have other people, because the assessors will say, well, how do you do it when nobody's here? And they're like, well, I get a run and jump, and sometimes I fall back down, or, I do this, and that you shouldn't get points for making it work unsafely. Right. Or you shouldn't not get points. Yeah. Right. Yeah. You should get points if you're not able to do it in a reasonable way.
So mobility the mobility function is always it's only asking in your home. The question is not, can you get around outside the home? The question is, can you get around in your home? And it includes if you can use a wheelchair, a cane, a walker, any of that. If you're mobile without assistance from another person in the home, using whatever you need to be mobile with, that's no points. So if somebody can transfer, say, from the bed to a wheelchair, and then get around the house in the wheelchair, they get no points for transfer or mobility. So they've got to need help from another person. Now, if they can kind of get up, but they keep falling back down. If I try enough times, maybe I can get up. That is really not able to complete the task independently. That's the question, is, can you do this independently? And if you need somebody, if only 1 out of every 10 times you try to get enough momentum to sit up, can you do it? That should be noted. Eating. If someone can put a piece of food on a plate in front of you, you can get that piece of food from the plate to your mouth and swallow it without choking, you get 0 points. If you need verbal cueing to do that, you could get some points there. You have to, the question is, can you do this independently? And the only thing they're looking at is, once that food is in front of you, can you independently get it into your body? So having somebody there to watch you to make sure you don't choke, having somebody have to cue you, all of that should be, no, I actually can't do this independently.
But neatness doesn't count.
Neatness doesn't count, David, so you don't get any points. Toileting, incontinence care, and catheter ostomy care. So toileting, this is not just a question of can you get to the toilet. It looks at your ability to pull up and down pants, to clean yourself, pull down pants, clean yourself, pull back up pants, make it to the toilet. And it's the same with incontinence care. If you say wear adult diapers, but you can't get your pants down to change the adult diapers, you need assistance with incontinence care. There is, it's getting detailed here, but if somebody asks them, okay, you say you can clean yourself, do you find stains in your underwear afterward? If so, you can tell that to people. This is help that they need. They need help cleaning themselves. A lot of people do not want to talk about that, but this is a question of whether they get any points for this or not.
When I'm doing an intake with an adult child, I always ask, do you help with the laundry, to get to that question. So. And
then orientation. So orientation to person, if someone doesn't remember their own name or names of immediate relatives. Place is, it doesn't mean I don't know the address where I am. It's, I don't know where I am. If they think they're in a different state, if they don't know if they're in a nursing facility or not, that's orientation to place. And then situations, can they make a decision about their safety? If there was a fire, do they know, oh, I should leave the house if there's a fire? If there's some sort of emergency, do they know what to do? All of those could be points for orientation. Then there's expressive and receptive communication. Expressive communication, the ability to communicate to other people. Receptive communication is the ability to understand other people's instructions and things without continual intervention. This is just verbal, receptive communication. And if somebody, it's got to be in a manner that they can understand in their expressive communication. They have to be able to, not just to talk, but to communicate.
Oh, can we go back?
Yep.
Katie Ann Twiggs is our paralegal at our office who, she was a choices assessor at ETHRA. And when she's talking about expressive and receptive communication, receptive particularly, she describes one time she was at an assessment and she was asking the client, just to do, or the enrollee applicant to follow some basic commands. And she said, hold up your right hand. And the client complied and she said, now touch your nose. And the client, she looked confused and she just went and clapped her hands. And like, she could tell that there was something she was supposed to do, but she couldn't quite get there. And Katie Ann gave her a point for receptive communication. So.
And I mean, one of the reasons we're telling you all this detailed stuff is because there is a great variety and difference between, you could have 2 PAE assessors, somebody can give somebody a 0, somebody can give them a 9. I mean, that's the level of variation that we sometimes see between what points they're giving. And often it's a question of just knowing what questions to ask or what answer somebody happens to give at a certain time. Self-administration of medication. So this looks whether people have both the cognitive or physical ability, the physical ability to administer medication. So pills or tablets, if somebody can put a pill in their hand and they can put it in their mouth and swallow it, they can administer pills. If there is an ongoing issue of, say, dropping pills or not remembering if you took them, you can use that as evidence that this person is not able to do this independently. And getting a letter from a caregiver just saying, every time I was there, she doesn't know if she's taking her pills or not. Check, or she drops it every time and can't reach it on the floor.
Katie Ann has a story about this one where she scored somebody for medication. When Katie Ann went to visit, the lady was blind. She was like, yeah, I take my medicine fine. But Katie Ann saw pills all over the floor next to her chair where she kept her medicine. And so she realized that she was not getting all of her medicines.
Also, creams, patches, eye drops, ear drops, those kinds of things. The one thing that doesn't count here is insulin, because that's a skilled service, it's a separate, so it's not counted in self-administration of medication. Over-the-counter medications also count. So this doesn't have to be just ability to administer prescribed medications. Somebody had it, and it still needs to be a medication, but if they have say a topical antibiotic or something like that, if they can't administer that, that counts. Refusal to take them or needing limited assistance with them does not count. So that means reminding, just because they don't, if somebody could come and lay out the pill box for them of all their pills every day, if they have to have somebody to do that and would not know what to do without that, still no points. Not a question of whether they can remember to take their pills, whether they have to, can refill their pills, whether they can read labels. The question is, can they put the pills in their mouth? Can they put the eye drops in their eyes? And this has to be the result of a persistent, ongoing impairment. This can't be just, she forgets sometimes. This has to be a daily or at least 4 times a week issue. And then there's behaviors. So look here. Intervention, need of supervision, that's one thing. Those are behaviors, things like getting lost, wandering, aggression, taking off clothes, eating non-edible things, all of that can be counted. The question is, intervention and supervision needed due to an established and persistent pattern of behavior problems? So wandering once or taking off their clothes once because of an acute episode is not going to get the points here. An ongoing issue. It also can't primarily be related to a mental health condition or substance abuse disorder. This has to, meaning this can't be, they can't wander when they get depressed. It has to be an ongoing cognitive, persistent behavioral pattern. And without the supervision or intervention of another person, it would place them at risk of immediate and serious harm. And just because someone has only wandered twice, if they have, let's say they have a caregiver there, and this is one of those that we often run into situations where they grant someone a service, let's say they get home health, private duty nursing for a kid with a seizure disorder, and then the kid stops having seizures, and they say, therefore, you don't need private duty nursing anymore. This kind of thing happens here. If they've wandered twice, but they're already on choices and they're being redetermined, they're getting a new PAE. And they say, well, she hasn't wandered in 6 months. The thing to say is ask the caregiver, okay, have you had to tell her, oh, you can't do that, come this way. Intervention to stop wandering should be counted in this. It should go toward this behavioral measure. So just because she hasn't made it out of the house, if she's actually got services, then it should still count. Any questions on the acuity scale? It is a very strict, completely non-scientific scale, and we hope they're going to make some changes on it someday.
Ultimately, the determination of the administrative judge, though.
Yeah, we'll talk about appeals also. Okay, safety determinations. What if someone does not score a 9? I think we talked about this in the Choices 101, but a little more about it here. So a reminder, if someone doesn't score a 9, but they cannot be safely kept at group 3 level with that $15,000 cap, even if they're not eligible for group 3. It's an important thing to remember. The question is, can you be safely kept with group 3 services? You stay at home safely. Doesn't matter if you're actually eligible for group 3 or not. So if you're a non-SSI recipient, the question is still, the question is, can you be kept safe at a level of services below group 3 level of services, despite the fact that you can't get them?
You assume everybody's on SSI for
Yeah.
purposes of safety.
Yeah. Did we not do the
What?
The new slide?
I don't know. There's another one after this.
Okay.
Yeah.
Sorry. So the questions that you ask for a safety determination. So for most of the functional measures, would not receiving this care result in imminent and serious safety risks? So these are things that should trigger a safety determination. You have a right to a safety determination based on these. Has the client experienced a significant change in physical or behavioral or functional needs? Changes in the caregiver. So you might be able to get a safety determination if you've had the caregiver has different needs. Pattern of recent falls or hospitalizations, patterns of self-neglect involving adult protective services or law enforcement. This is the list of things in the TennCare rules. There's more of them in the TennCare rules than this, but these are the important ones that they say, these are the things that allow you to get a safety determination. This is not necessarily what they're evaluating. What they're evaluating is, can you be kept safely under $15,000? That's what they're looking at in safety determination. These are who is eligible to even get a safety determination. But the big problem is they don't tell anybody about safety determinations. Nursing homes know about it. So they know, nursing homes know how to get people eligible because they know about the safety determination. An individual, particularly an individual, I guess it would be anybody who's applying, whether they're already on TennCare or not, they might be lucky enough to find either somebody with MCO or somebody with the AAA who knows about safety determination. Says maybe you should ask for that. Most of the time they don't. And what you're going to see once you start getting these hearing packets is didn't request a safety determination. So we didn't do one. The problem with that is that there is under the Medicaid regs, there's a requirement that every applicant for Medicaid or for any enrollee be given both a paper and an electronic copy of their rights and responsibilities and all eligibility criteria for the program. Safety determination is an eligibility criteria for the program. So what we're using in hearings, safety determination is the place where we often try to get people eligible. We say, well, you're right, we can't get them to a 9. But we do think they're eligible as safeties. They cannot be kept safely at home for under $15,000. TennCare's response is they didn't ask for a safety determination. So we only look at what we evaluated at the time. They didn't ask for it, therefore it can't be considered here. That's when we say, oh, no, actually, therefore, if they didn't ask for it, can you please provide me with a copy of the written form telling them about their right to request a safety determination, which of course doesn't exist. That's the argument there. We'll see how it works out. With all these arguments, we sometimes didn't quite fit in the case that we've got, or the argument ends up being settled in a different way. That's what we're going to try to do.
I had a hearing with this issue a couple weeks ago, and the TennCare's witnesses, the eligibility specialists, what they kept saying was the assessor didn't ask for a safety. The assessor knew that she could ask for a safety, but the assessor didn't. It was almost like assessors are allowed to check the box if they feel like it, which I'm sure happens for assessors like Katie Ann, but for a lot of them, it just means extra paperwork. So essentially, in order for a person who doesn't know about a safety to get a safety, somebody has to, on their own, decide to do more paperwork. So it didn't make sense. So.
Yeah.
What happened in your hearing?
We don't know yet.
We don't know yet. That's why we don't know if it works. I'm recommending to you theories that we have no idea if they work or not.
I'll share good news.
So for the safety determination, I had a case where my client just got 1 point on the scale, but because they found that she can usually transfer herself, but not, so that just gave her 1. So that was like 1 to 3 times a week she needs physical assistance from somebody else. So TennCare's argument is that they don't have to do safety determinations because unless there's been a finding that there's a need for help with the activity of daily living for 4 or more days per week. And so now we challenge that she really should get more than 1 point. We ended up getting a safety determination ordered, and she still didn't end up winning, but that was for
Yeah,
reasons.
that's, I mean, they use that argument because in their mind, they think you have to score a 5 or more, 5 to 8 to get a safety determination, or maybe some of the other functional measures. That list, if you look in the rules, that's only one of the criteria that make you eligible, and it's all or. You have this, or this, or this, or this. So if somebody, for example, if somebody's just gotten out of a nursing home, they're still, and they're trying to get on choices, that's supposed to trigger safety. Or at least the right to request a safety if somebody tells you about your right to ask for a safety.
It's spelled out in the rule, but it's subsection A is you have to score a 5 or between a 5 and an 8, but then there's B, C, D, the whole next page is.
Right, I know what you're talking about, but
Yeah.
there's another part of the rules that talks about just when safety determinations come up, and it says that you need activities of daily living. Anyway, we'll talk about it.
I mean, most of the time we've been able to get judges to just order safety determinations. You know, they'll take the proof, and you know, often we're not even really challenging the PAE score. We know we may have gotten the most or whatever we could get. It's not going to get them over the 9, but we think they're still good, you know, that they'll be eligible through a safety. Just go through the hearing, ask the judge, you know, please order, you know, if you, Your Honor, we can either now try to prove their eligibility through a safety by saying they can't be safely kept under $15,000, or you can just order them to do it since they haven't even done it yet, and we can just challenge that later. Depends on timing and things like that.
I think what Rachel's referring to is these are all criteria to get yourself a safety assessment. But then in the rules, there's a separate criteria where you have to have a significant deficit in one of the areas of the activities of daily living in order to win. So if you can't show, I don't know if it's a 2 or a 3 in any one of those areas, you can't get a favorable safety determination.
Yeah. So if you score a 0, then you haven't shown any a 0 or even 1. I mean, most of the time we get them. I mean, if we're going to argue for a safety, it's more than a 0 usually. But you may have to argue up the points as well, and also try to get the safety determination. The pre-admission screening and resident review, or PASSAR. PASSAR is a federal requirement for everybody entering a nursing facility, or for a Medicaid certified nursing facility. And what they're trying to do with the PASSAR, the idea of the PASSAR is we have a long and ugly history of warehousing people with developmental disabilities, mental retardation, mental illness, other things like that, that we don't just want to be putting people in nursing homes who do not have the physical needs for a nursing home, may need something else, may need another set of services or a different kind of institutional placement. So we don't want to just warehouse those people in nursing homes. So it's only required for group 1, because that's the only time you're institutionalizing someone. It's a 2-level process. So on level 1, they're basically it's an initial screen. They want to see, okay, is there any reason to think that you have either mental illness? These are all the terms they still use. So mental illness, mental retardation, or developmental disability. So any of these things, if you screen positive for any of these, and this could be either diagnoses, a history of that, and even all the way down to if an agency refers someone to the Choices program, and that agency, so let's say the ARC refers someone, then that would be a reason to get to a level 2 screen. If you pass a level 1 screen, PASSAR's done. If you don't pass the level 1, you go to level 2. Level 2 is asking, does this person require the level of services required in a nursing facility or in another type of facility? And if so, if they need specialized services, and that's really the question, is does this person need specialized services? And then is it appropriate for that person to get them in a different kind of institution or in a nursing facility? So there's some exemptions that even if you screen positive on the first one, you have a primary diagnosis of Alzheimer's or dementia, there's convalescent care or terminal illness, or comatose, ventilator dependent, brainstem function. Any of those doesn't matter if you pass the PASSAR or not. The reason I'm including this, most of this is really done behind the black box. It's pretty rare that we've had to challenge them. The place where we do have to challenge them are people who don't pass. I mean, they get screened to level 2. So there is some diagnoses there. Once they do that, TennCare's position in some cases has been, oh, you can't get to a nursing facility. That's not what these are for. This is not supposed to block the door to a nursing facility. If somebody meets the level of care criteria for a nursing facility and they can, with specialized services if they need them, be cared for in a nursing facility, they should get that. It should not be just, you didn't get past your PASSAR, you can't go to a nursing facility. That should not be happening. So if it does, you can challenge it because the rules are pretty clear about what they're supposed to evaluate, whether they could need specialized services in the facility. And then,
That's what the nursing home look at the PASSAR. How is TennCare denying them?
they'll just say you can't get choices. You didn't pass your PASSAR, so you can't get choices. Say, no, that's not what the rule says. The rule says you then have to see where the appropriate placement is, and if it's nursing, if they still meet the criteria for a nursing facility, if they can get specialized services for whatever the cause for the not passing the PASSAR, they have to offer that in the nursing facility if that's.
Is that put that in the notice? You don't pass your PASSAR?
Yeah. Russ's favorite subject, effective date of choices. So for group 1, it's pretty easy because the nursing homes, they're power players. So once they complete the PASSAR, PAE is approved, the effective date of Medicaid eligibility, the date of admission to the nursing facility, and the effective date of enrollment in group 1. Basically, all of this for nursing facility takes place behind the scenes, and we leave it to them to fight it out with TennCare. And we're not fighting for nursing homes to get paid usually unless they're coming after our clients. The effective date for choices group 2. Anybody know when the effective date for choices group 2 is? It is whenever you are enrolled in group 2 and start receiving services. There is no time when that starts, and you can't get retroactive on community-based services, obviously. So TennCare, I mean, the rule really is whenever TennCare gets around to it is when you become enrolled in group 2.
Within 90 days of your application.
It should be within 90 days, but they could send you a notice that says you're eligible and still not actually start giving you services, and technically you're not eligible within 90 days. You should, if this comes up, still I would use the 90-day rule. They have to have your eligibility determination within 90 days of application for choices. If you're still not getting services at the end of that 90 days, I would say that's, even if they send a notice that says you're eligible for group 2, if you're not getting services by then, I would say, well, you haven't met your requirement there. Just sending somebody a notice does not mean that they're giving them eligibility within 90 days. But for TennCare services, it's important to always remember that choices comes with full TennCare. Some people may be eligible separately, but some people, the only way they're eligible for choices for TennCare may be through choices. Choices is all the specialized services that you can't get. So the attendant care and things like that. Your basic pharmacy, primary care hospitalization, all of that is still provided through TennCare. It comes with your choices eligibility. And it's through the institutional Medicaid category. Institutional Medicaid is for people who've been in an institution, something other than inpatient psychiatric hospital. If you've been in an institution for 30 days, you can become eligible for institutional Medicaid. It's also the Medicaid category for choices, where technically what a PAE is doing is saying, we expect you to be institutionalized or to qualify for an institutional level of care for at least 30 days, and therefore you're eligible for TennCare from Medicaid under the institutional category. You're eligible for that on the date the PAE is approved. So this comes up, let's say somebody applies, they get their PAE approved, but they still haven't been enrolled in choices, whatever, they're waiting for that final determination. Once that PAE is approved, if there's any medical bills after that, let's say they go to the hospital, those bills should be covered. They might not, TennCare might not have them enrolled yet. They might not have put them in the system as choices enrollees, but they should be eligible as of that PAE approval.
Is TennCare accepting that now, or do you still have to fight that out on an appeal?
We haven't had to fight it out yet, but I know you've had a couple, right?
Yeah, and they didn't agree. It was a hearing officer decision that said it was the date of the PAE approval. Their position was it wasn't until there was a financial eligibility determination as well as a medical. So it was basically, you're not eligible till we decide you're eligible.
Right. And that's true for eligibility for choices, but it's not true for eligibility, or at least this hearing officer found it's not true for institutional Medicaid. That your date of eligibility will go back to the date that PAE was approved, even if it takes them another month to do the financial application.
So does that mean that if somebody has significant resources and they need 3 or 4 months to spend it down, their effective date is still going to be back to when they got their PAE?
I mean, the general federal Medicaid rule is you're not eligible till you're eligible. Yeah. And if you were over the resource limit, you're not eligible then. And I don't see any argument that you can make that you're eligible until your income is within the limits and your resources are within the limits.
Yeah. In these cases, I mean, there was an application put in that was just eventually adjudicated, and they were saying, well, you're not eligible until then. There is no backdating. And their theory is, well, since there's no backdating of choices, but most of the time in TennCare, your eligibility date is the date of your application for most categories. A couple of exceptions would be like spin down and choices, where so if you're applying for regular TennCare category, you apply, you wait, let's hope less than 45 days. They tell you you're eligible as of that date you apply. In choices, when you apply is not the date you're going to be eligible either for institutional Medicaid or for choices more generally. It's only going to be once they complete and approve the PAE. And if they later determine, yes, you were eligible when you applied, financially eligible, then your coverage will date back to that PAE approval, not to the date of application. But it's not whenever we decide, which is TennCare's argument all the time, is no, we got as long as we want, or at least 90 days to do it. Okay, any other questions on the PAE or safety determinations, any of that? Yeah.
Good question. Shelley and I talked about this before. I don't know if there's any rules about whether the assessor has to be there in person, but I think we talked about you should ask if they do in person, so they might get a lower score when they're not able to see what's actually going on. Or do y'all see that they're mostly coming to check on it in person?
I've not seen one where they didn't come in person.
Well, he's talking about phone screenings, which is where you call in and they say, can you walk? And the person says yes. And then they say, well, you're probably not eligible. They're supposed to send them out a notice that says, you still have the right to an in-person hearing or an in-person assessment if you want it. I'm not sure how regularly those notices are going out. And
but they do have a right to have an in-person assessment.
They always have a right to an in-person assessment, and we always encourage people to do it. Another thing Katie Ann helped me with is she said to pay attention to how far away the person's house is from where the assessor is, because oftentimes it's, you know, that'll eat up their whole day to go on out and have to do an assessment in the middle of nowhere. But to just tell the clients, and so we've had clients call back and say, well, I called and said, you know, I really wanted an in-person assessment and I had a right to it. And they kept telling me I wasn't eligible. You know, we've had to do three-way calls with assessors to get them in-person assessments, but.
And they'll do things like, I mean, ask questions on the phone, like, can you drive? And if you say, yeah, I can drive, and they'll say, you can't, you're not eligible. That's not one of the, I don't remember that on your acuity scale anywhere. But.
Do you all ever like get medical records? And a lot of times the doctors will say, he's not taking his medicine. I mean, they can tell you a lot. Do you all do that when you prepare?
Yeah, I'll talk more about it. Yeah, I've got, so Shelby's now going to do financial choices, and then I'll do appeals.
And I'm thinking about early on, before the assessor comes.
Yes.
What do you get all that stuff together?
Sometimes, yeah, especially if a client calls and says, I've applied for choices 3 or 4 times, and we go ahead and do the homework ahead of time, try to make it easy on the assessors so we don't have to do another appeal.
The doctor saying all this is different.
Yeah, try to get, go ahead and collect all the medical records, collect all the falls and hospitalization records.
And in fact, the rules say, and Shelby had a case where this came up in an ugly way. The rules say they send out an in-person assessor, and that in-person assessor says, oh, this person needs assistance with transferring 5 days a week. But there are no medical records that say that. Therefore, TennCare's position is therefore, because the rule actually says they have to be documented in the medical, that ADL deficiencies have to be documented in the medical records. So
And medical records aren't defined, by the way.
Right.
So.
Their own assessors go out, see the person, say they can't transfer, and still TennCare's position will be, oh no, there's no medical records documenting that, so you don't get any points for it.
We've only seen that in that one ugly case.
And I think we've faced the argument, the judges have been a little, as long as there is some disability or impairment that explains why someone might have trouble reflecting the medical records. They're not looking for doctors to say, this person needs help transferring 5 days a week, which no doctor says.
Yeah. Financial. We get people sometimes, not super regularly, but they'll call in and they'll say, I tried to get choices, but my income was too high. Because for, as you heard earlier, all the other TennCare categories, it's all income-based. But for choices, it's kind of upside down. So I think of the medical eligibility as kind of a rock climbing wall. Like, you can get over it, but it's a challenge and it's tough. But the financial is just a hurdle. Like, it's quick, it's easy. If you know what to do, you can get over it just fine. And usually if you can climb a rock climbing wall, you can jump the hurdle. So never let somebody come in and say, well, I'm just not financially eligible. I'm just right over the border. That's not how choices works. You can get around resource and income eligibility, which we'll talk about. Oh, that's big. Okay, so income. It looks at the gross income of the applicant, so that means before deductions for the most part. There are a few exceptions, and only the applicant's income counts. So for the other TennCare categories, we talked a lot about household size and couples. Since this is an institutional category of Medicaid, the fiction is that even if they're at home living with their families, they're institutionalized, and institutionalized people are always households of one. So it's just the applicant's income. Resources we'll see that is different, but for income, at least, just the applicant. So it is capped. The income limit is $2250, and last year that was $2205. So some people think that's a typo. No, it's just the COLA this last year. And if you ever forget what it is, it's just whatever SSI full benefit rate is times 3. It's always that $2250 this year. But so the income is capped at $2250. The average cost of a nursing facility is more than $5,000 a month on average. That doesn't make any sense, does it? And I'm going to go over just a little bit of my QIT presentation because I think there were some questions that didn't get brought up. So maybe if you guys have those questions now, you can jump in with them. But just a few minutes on the QITs. They're called Qualified Income Trust, Qualifying Income Trust, and Miller Trust. We hear around here, at least I hear the first and the third one the most often, Qualified Income Trust. Miller Trust. Qualifying Income Trust I think makes more sense because the income isn't qualified. The income does, the trust does the qualifying. So that sometimes I explain it to clients that way. Sounds weird and scary and hard. It's just a bank account with special paperwork, and it makes income, it goes into an irrevocable trust, so it makes it legally unavailable. So it's not counted. I always include this. Some clients, they say, so who are you again? And what am I doing? Why am I moving money around to make it not count? It sounds fishy and bad to them. I sometimes, if they're really uncomfortable with it, I just send them a link to the rules. I say, it doesn't make any sense. It's really silly, but the state makes us do it. So we do it. That's how you get there. So then just the basics. You guys have already heard this. The beginning of the month, the trustee moves the Schedule A from the checking account of the applicant into the QIT. You can't direct deposit into a QIT. Then at the end of the month, you move the entire Schedule A out. Schedule A is basically however much you're over. For Group 1, the entire Schedule A usually goes to the nursing facility. Group 2, the trustee should spend the money on an approved expense. And that's where we get into trouble because all of this infrastructure was developed for Group 1, like a lot of the other choices rules. So it makes a ton of sense for nursing homes. Everything goes to the nursing home anyway, except your $50 you get to keep. It all works out. For Group 2, some people end up with $1,000 or more stuck in this account, and there's only so many ways you can get it out. So that leads to the most common problem that I see with QITs, and I see it several times a month. People calling in, so I put all this money in here, now what am I supposed to do with it? The trust document itself has all these rules attached to it. The answer is there's really not a whole lot of options and even fewer good options. The rules just didn't really contemplate what exactly people were supposed to do with all this money. So these are the 5 allowable expenses from the TennCare rules. A personal needs allowance, we're gonna go through all these one by one later. So personal needs allowance, item D expenses, health insurance premiums, including Medicare, up to $20 for bank fees and patient liability. Those last two actually, I don't think we're gonna go over. $20 for bank fees, bless her heart. I had a client call me needing a QIT. I said, okay, get me this. And then she called me back, or I sent her the QIT, told her just what to do. She called me back and she said, well, they made me put $500 in it right away, or else it was going to cost $20 a month for bank fees. So I just went ahead and put $500 of my own money in it. First of all, you're not supposed to put your own money in it. And second of all, I feel like I'm sure I told her that you can deduct for bank fees. Really, she didn't hear me. She didn't hear me. She was really nervous about it. So I never made that mistake again. Always tell them, don't worry about the bank fees. I know you're going to be keeping a low balance in it. You get a deduction for the bank fees. And then the last one is patient liability. So some organizations and law firms, elder law firms, advise their clients to just put all of their income into the QIT and then work out of it and just spend out of these allowable expenses. So, spend your patient liability out of it. And that may work for some people, but it's an irrevocable trust. And I never prefer to advise clients to put more money into it than they just have to. Because if something happens, it's hard to get out. And once the trust terminates, it all goes to TennCare anyway. So if you don't have to put money in the thing, I never would. Maybe that works for some people. But another problem with QITs, it's not really a problem, it's just kind of a quirky rule, and it's something everybody should be aware of. Aid and attendance is a VA benefit. So if somebody's already receiving a VA pension, and then as they age or they become disabled, they need aid and attendance of another person, so hands-on assistance is how we would say, or they're housebound, and there's a specific rule for housebound. It's not literally housebound. There's some it's the rule something like it's difficult to leave your house and you only go places like the store and church, and it's they're not going to amusement parks is really how I kind of read the rule. So that's aid and attendance. So you have your regular VA pension, and then once you meet the rule, you get this bonus money that's aid and attendance. It does not count as income for purposes of the QIT. And then, so let's say it's $200 that you get extra, that's just aid and attendance. Your QIT, when you're adding up your gross income, you do not count that $200 because once you get approved for choices, it drops down to $90. So you still get your aid and attendance, but you only get it in $90. So that means you'll have your personal needs allowance plus your $90. As basically if you're on VA aid and attendance, you get bonus personal needs allowance. But it's not ever counted for purposes of the QIT. Practically, TennCare several times has told my clients, we don't count VA income. We had a client who she definitely needed a QIT. She had aid and attendance, but even if we excluded it, she still needed a QIT. We reached out to the TennCare eligibility person. And they said, oh no, all this is VA income. It doesn't count. So somewhere in an internal manual, they have something that says no VA benefits count. That's not right, but if they just give me a number to put in QIT, we'll put that in QIT until they're dissatisfied with it. So any questions about that? It's kind of a weird rule. Don't count it is the bottom line, and it'll be nice for your client to have extra dollars. And just if they're in a nursing home, they may have really low personal expenses. Just make sure they don't get over-resourced with their $110, $140 a month. Okay, so patient liability is essentially a copay for nursing home care. The law, they say that they require patients to contribute to the cost of their care. Groups 2 and 3 generally have no, or theoretically it's possible they have patient liability. I don't know if I may have had one client who ever had patient liability. It was like $7 maybe. They just pay it to the MCO. So this is a post eligibility determination. So all the QIT stuff that we were talking about, gross income, everything like that, it's a different set of rules. That's pre-eligibility treatment of income, and the TennCare policy manual separated out pre and post eligibility. Patient liability is a post eligibility determination. So that's a different set of rules. So patient, do you have a question?
Is patient liability if your income exceeds 2 times the SSI amount?
Let's
For choices 2.
for choices 2. Well, let's.
Okay.
I think I'm going to get to your question. I don't quite understand it, but
Okay.
I'll come back to you. So it's mostly people in group 1 in a nursing facility who have these patient liabilities. So calculating patient liability, the basic way to think of it is you take all of their income, you subtract out deductions, and whatever's left over is what they owe the nursing home at the end of the month. So then these deductions, we're going to go through, these are the ones we're going to go through one by one. So the first one is the personal needs allowance, and everybody gets that deduction. The amounts differ based on what group you're in. We'll get to that in the next slide. There's also these spousal impoverishment rules. So basically, just because someone goes into a facility, we don't want their spouse or their dependents to become impoverished. So there's some special deductions for people who have community spouses or dependents. And then medical expenses paid by the enrollee, and then item B deductions. And we'll talk about all these in turn. But they're really important, especially for people who go into a nursing. I mean, I would say most of my clients, they go to a nursing facility, they keep $50 to buy their clothes, the rest goes to the nursing home, doesn't matter. But for the client who has a family still at home, these deductions and working through them, even though they're really complicated, can be a difference maker. In a lot of cases, in whether or not they will consent to seek the care they need instead of impoverishing their family. So personal needs allowance, this is the easy one. So if you're in group 1, it's $50. So that's, you're in a nursing home. The logic is they're providing for all of your needs. You don't need anything. You may need a haircut or some new clothes, but other than that, you're mostly covered. Groups 2 and 3, it's $22.50. That's the same as the QIT amount. So it's basically, if you have QIT, you get to keep the rest of your money besides what's in the QIT if you're in groups 2 and 3, which is why they don't usually have patient liability. So, and that's obviously also SSI times 3. So this beautiful thing is the Community Spouse Income Maintenance Allowance. And it's one of those anti-impoverishment laws I was talking about. So the two actors in this, the maintenance allowance, are institutionalized spouse, who we would call the enrollee or the applicant, and the community spouse, who is their person that they're married to, who lives at home. So this is not an institutionalized person. You can't, if they're both receiving, or if one of them is, if they're both receiving HCBS, they can't get these. But if one is a community spouse, so is not institutionalized, they can get it. So here is the formula, and it looks complicated and hard, but it's really important. And if you just think about it a little bit, and it's kind of like the magic eyes, if you cross your eyes a little bit, it starts to make sense. So we start with the standard maintenance allowance, which is a fixed number. And for right now, that number is 2030. And then you add that to this excess shelter allowance. So to calculate the shelter allowance, you take basically their rent, utilities, whatever their shelter costs are, and you subtract out 609. That's another fixed number, but changes from year to year. So 609, they say, is, you know, that you should be able to cover your expenses for that. So whatever is over 609, they say, is your excess shelter costs. So you add up 2030 plus the difference here, and then you subtract out their income. So basically, what this is trying to get at is, if their costs are higher than their income, they get to deduct some patient liability from their spouse. We have about 4% comprehension right now. That's okay. So the idea is, what this is designed to get at is, if they were depending on the spouse's income to meet their costs of, you know, because they're still going to have to maintain the home, things like that, then they get a deduction in the patient liability. If we have, you know, if you have a client, this makes a lot more sense. But yeah, so it's especially helpful for men who have higher have higher retirement, and they have pensions, and then the women, their wives, who, you know, stay at home, didn't accumulate as much work history. If the husband goes into a nursing facility and they take all of his money, she has nothing left. So she would get, in that situation, the wife would get a considerable CSIMA. No one can even formulate a question.
I'm afraid to ask this. This only applies when the person is in a nursing home?
Yes. Yes, because one has to be, I think so, Russ. I looked that up yesterday. I think that's true. The question was whether this applies to people in nursing facilities or in the community. Yeah.
Do y'all find that TennCare screws up this calculation pretty regularly?
I don't have a ton of them, actually. But yes, they have. And not so much this one as the next one, is the dependent income maintenance allowance. But it's always a good thing to double check them, because if they're getting it wrong for your client, they're probably getting it wrong for everybody else.
So if you know that you have a client that this is going to be an issue, I have one of these and I submitted it all as a packet in the beginning with the financial eligibility, like my own calculation of this to give them a starting place. Do y'all do that as well?
I've done it for this next one, the DIMA. I've never had a case with this, but it's something I always keep in mind. But I do them. If a client comes in and, you know, this is my patient liability, I will go ahead and check the math, and usually it's right. So, anybody else have any experience with this? No? Okay. So then this is the dependent income maintenance allowance. This is a lot rarer because Choices is a program. I mean, most of the enrollees are older. They don't usually have as many dependents. But I did have a client, the one I was just talking about. She was in her late 80s, but she had adopted a teenager, 2 teenagers actually. So her 2 teenagers got this deduction. So the dependents that count are the individuals or their spouse, which is important, adult dependent children, parents, siblings, and minor children who live with the community spouse. So it's pretty broad. You can basically get a deduction to keep the family afloat, make sure that their expenses are covered. The formula for this one, I didn't even put it in here. It has so many sub-formulas. It's in the policy manual. It's pretty easy to find. Less easy to use, but it's fine. Any questions about this one? Okay. TennCare had not assessed this one at all. They just didn't even consider it. I guess because she was in her late 80s and was widowed, so they didn't even look for dependents. I'm not even sure if they had the information. Okay, medical expenses. So I guess bigger picture, let's just think. So we have our patient liability and we're working through, or we have our gross income, we're working through our deductions. So let's say we have somebody in a nursing home, we deduct $50 from their patient liability. Let's say they have a dependent and her community spouse allowance is $200, so we deduct that. So we're just kind of like working down to try to lower that patient liability to make sure that the client can keep as much income for other things as possible is sort of the point here. This is another one that's medical expenses paid by the enrollee. The rule mentions health insurance premiums and Medicare Parts A, B, C, and D, which I thought were premiums, but whatever they want to say, it's relevant in the month of enrollment is the only time I can think that this would be relevant. If you're on choices, you have TennCare. You're not going to have premiums on TennCare unless you keep your Medicare supplement. We don't recommend clients keep their Medicare supplements if they're institutionalized. Most of the time, you can call your private insurance company and suspend it. I think that's a pretty typical thing that they do. Usually in something like this where I tell my clients to try it and I don't hear back from them, I assume it went well, if that happens over and over. So I think the insurance companies do that pretty regularly. So yeah, the only thing I can think of is if they've already paid their health insurance premium or their Medicare premium for the month, then they get approved. They can probably get a patient liability deduction for what they already paid in the month of approval. So I don't really know what that one means. And then this horror show, item D deductions. Item D is there's not like an A, B, and C. It's just sort of random. They keep calling them item D deductions. They're basically medical costs that aren't covered by TennCare or any other insurance that the person has. So that's sort of the rule, but the things you should think of when you hear item D deductions are these right here. And item D deductions are important for getting a deduction in patient liability, but they are also one of the few things that you can spend out of your QIT on. So if you hear I need eyeglasses, hearing aids, dental services, prescription drugs, or over-the-counter drugs, nursing home bed hold days, or if they have old bills, which we'll talk more about that later, perk your ears up because they're going to need to, they might as well spend that out of their QITs. That just makes sense. It's going to be trapped there otherwise. But also they can get if they don't have a QIT, for example, they can get a deduction. So they'll have to pay for it on the front end somehow, and then they can get reimbursed by sending it, I think it's on the next slide. But this last one is really the most important one. Chris talked a minute ago about effective dates of coverage. So you can't get backdated choices. There's no such thing as backdated choices, except kind of there is. And I have a suspicion that this is something that the nursing homes cooked up for themselves. But this last one is medical bills incurred 3 months prior to the month of application. So say your client applied for choices in April, so January, February, March. If they incurred any medical bills on those days, including nursing home stays, they can get prorated breaks on their patient liability moving forward. So basically the idea there is that TennCare will lower their patient liability so that they can pay off their debt to the nursing home is usually how it works out. The only reason this has ever been relevant to me is when a nursing home gets somebody, they were having trouble getting them on choices. They finally did get them on choices, and the client calls, or the client has some behaviors that are difficult to manage, their needs are high, they're for whatever reason an undesirable resident. The nursing home will try to get rid of them. They say, well, you have this giant debt, you haven't paid your bill. Sometimes I have to step in there and say, well, business office, have you guys submitted an item D deduction for the stay? And usually that covers a significant portion of the debt moving backward. So it basically, for the nursing homes, it helps them get paid, but it's fine if it gets them off clients' backs. And it's not like it costs the client anything because it just means TennCare picks up more of their nursing home bill moving forward. Any questions about that? So to submit an item D, And again, this is usually something that the nursing homes do. The only time I ever have to deal with it is if the nursing homes are being uncooperative for whatever reason. Just have to get these 4 things. Basically just prove that you paid for it, prove that you needed it, and prove that it happened. And then send it to TNHC ? They're supposed to be the ones who deal with it. Not sure how good they are at dealing with it. Yeah. Okay, so that was all income stuff. So it was about how to get under income, and then how to spend out of your QIT, and then how to lower your patient liability so that you can keep more of your income. Now we're moving on to the second half of financial eligibility, which is resources. Resources are capped at $2,000. For married applicants, it's the applicant's share of the resources. And the definition of their resources, it's the equity value of everything they own, everyone in the household owns, unless they're specifically excluded by a rule. So it's really broad. It does include spouses, but there are some wiggle room there. There is some wiggle room. So important resource exclusions. So I said everything counts except, this isn't an exhaustive list. It's just the ones, it's everyone that I've ever seen, plus this bottom one, which I thought was interesting. So the most common one is their homestead and adjacent land, unless it's worth more than $572,000, or not if it's worth more than that, if they have that much equity in it. I've never run across it, but I guess it could happen if land was really, the value appreciated quickly or something like that. There's actually an exception to this that I found yesterday when I was researching this. So if there's a relative who still lives in the house, the equity cap doesn't count, which I didn't know before. And then it doesn't count, your homestead doesn't count as long as you subjectively intend to return to it. That's very, very loosely interpreted. I've never heard TennCare argue, well, actually, there's no, the feasibility of their returning home isn't relevant. Just whether or not, if they were able to, hypothetically, would they like to return? Answer is always yes. Homestead's always excluded. Yeah. 1 car for the whole household is excluded. So if you have 2 cars, exclude them. You get to pick which one to exclude. Exclude the more expensive one, of course. Certain burial arrangements. So this is usually a burial contract, some kind of burial trust, or a life insurance policy if the cash value of the life insurance policy is a counted resource. But the trick there is to assign it to a funeral home. And the funeral homes love doing this. They're really good at it. They do it really fast. They get you their paperwork because they want you to prepay for everything and lock down your business. So I've never had a client say, well, they wouldn't tell me how, or they never have problems with that. The funeral homes are always very happy to help. Also household goods, personal effects, personal jewelry. Like if you have a jewelry collection, that's going to count. An engagement ring or family heirloom is not going to count. And then this last one I also found while I was working on this. So if you get back pay from Social Security, you have 9 months to spend that down before it's a counted resource. So I don't know. Has anybody ever had a case where they said somebody was over-resourced for a back payment? No. Well, in the future, when you do, they have 9 months to get rid of it all.
Yeah, of course.
Yeah.
On your burial arrangements. I want to have a client that went and paid for a burial qualified for $25,000 for it, and DHS was, and it's all get out. There was nothing they can do because it was a program, and that's exactly what he did, and eligible.
Yeah, it's gonna be a party.
I think it was 14 camera frauds. It was nice. Camera frauds got down. But he did it. They were hot. I mean, hot.
But there's nothing they can do once it's
They
irrevocable.
can do about it.
Yeah, I had one where it was not such a good situation. It was a funeral that expensive, but the son had signed on to make payments for it. So after dad's money ran out, son was still paying for it, but nothing we could have done about that one. Any other questions about, yeah?
So a couple of things, just one, I'm seeing more clients with life estates and property that they're not living on.
Yeah.
And, but I found a good policy about how it can be considered an inaccessible asset if you can get 2 real estate agents to say that the life estate's not saleable. I thought I'd mention that. And then, of course, the life stayed in their own home where they're living is excluded as just like their own home, but this is like life stayed on other property. But then a question I have is, I've got one client where the adult children just, I mean, they're actually good children. They just like don't let mom pay for anything.
Yeah.
But then mom's only gets that $800 and something in Social Security, but it's accumulated up, and so now she has several $1,000s in her checking account. And then they took a big chunk out. I think probably because somebody told them you can't, you have to have less than 2,000.
Yeah.
And they can't seem to really tell. I mean, they have like a few like receipts of what they've done with that, as far as like new cars for the Jeep that they drive mom around in, and then like stuff like that. But if they reapply now with the look, I don't think you've gone to the look back
Not yet.
situation, but think about that. If there's, I don't know what to advise them to do.
So wait, so they saw that mom was over-resourced, so they
don't admit this. They just are like, we just were paying ourselves back. And it's like, okay, what were you paying back? And then like, they have some receipts, but it's not adding up to the $3,000 that they took from mom's checking account. Well, I don't think, and even though I do believe that they are like, we're paying probably all of mom's expenses.
Yeah.
And I really believe that, but I just don't know how to prove it for them.
Can you make them put it back?
But they put it, that's a good question.
Yeah.
So
put it back.
If they put it back and then spend it again.
Yeah.
And keep the receipt.
Yep. Keep the receipts this time. Or if you say she's a new applicant.
So she has a pending appeal, but I'm wondering if we need to do a new application after they send down appropriately. But then I'm afraid they're gonna look back at 9 months ago when she applied and see like, what about that $3,000 from last September?
Yeah, I think that's probably the best idea, is just to have them give it back, start your paper file right now. They gave it back. We were sorry, we didn't understand. Then they're paying her moving forward and keeping good records.
Okay.
But my other thought would be if she's a new applicant, if it's $3,000 and they can prove some of it, that's going to be less than a month that her penalty period is. So I wouldn't be too terribly worried about the penalty period. I would say rather than filing the application, just prove as many expenses as you can.
Okay.
Would be my
So
thought.
she's only penalized for what, a month?
Less. It's a daily rate. So however much was transferred for less than fair market value. Yeah,
Okay.
but we'll get to all that.
Okay. Sorry.
Any more questions about these exclusions? No. Okay. So how resources are counted. This is sort of so upon institutionalization, so that means when you go to the nursing home, even if Medicare is still paying, you can go ahead and do your snapshot. And I'm not sure if any of you guys are familiar with this, but TennCare has a book. It's like Elder Law in Tennessee or something. It's fantastic. I look at it just probably every other day. And he suggests to do the snapshot early, send in all of your records to TennCare, and you can do this well before you apply. So it's just upon the date of institutionalization. And the rules define what it is for home community-based, and I didn't put it in here for some reason. So yeah, get your snapshot, and what they'll do is they'll count it all up together. Let's say he has $25,000 worth of stuff. She has $35,000 worth of stuff. Doesn't matter how it's titled, and it doesn't matter how long they've been married. So it's all of the household resources get mashed together and then split down the middle. So even if 25 is hers and 35 is his, combine it, it's going to be 30-30. So then the applicant, I think it was the she this time, has to spend all the way down to $2,000, her resources. So then the family, the household together can have 32 combined. And so you don't have to, it's not split by thing, it's split by value. So if you can get rid of the cash value of the life insurance policy, or get rid of assign both of their life insurance policies, it doesn't matter, as long as as a family they're spent down to half minus without, and leave 2 on one side. Does that make sense? Yeah, Russ?
So if you've got a spouse trying to get choices who has $4,000 in savings, and the other spouse has 0, that spouse is eligible.
Both of them are good.
Okay. And that applies to choices 2 as well as choices 1.
Yep.
Okay.
Same resource rules. Anybody else? So here we go back to 5-year look back. Applicants can't get rid of resources for less than fair market value. Can't give anything away, can't sell it for too cheap. The way that most people see this is they haven't done their Googling. They see that mom's health is declining. She's not able to take care of the house. They just quit claim the house to the children, or they just transfer assets to the children. We'll take care of it. It'll be easier for everybody. Usually there's nothing nefarious going on. It's just the way the family's working. But if she needs to apply for choices within the next 5 years, they're going to be in trouble for that. The state's position, and this isn't a TennCare policy, this is a federal policy, but the government's position, I guess, is that if you have any sort of asset that can be converted to cash, you should be using it to pay for your own care. So if you are giving things away, then we're going to penalize you for not spending it on your care, for giving it to somebody else. Yeah, so that's 5 years that they look back for that. So then the penalty period is what we were talking about just a second ago. TennCare will refuse to make choices payments for a time period proportional to the assets transferred. So let's say that choices costs $5,000, or to be in a nursing home costs $5,000 a month. You have a house where you have $20,000 equity in it. You just give it to your daughter because it's getting too much for you, or just because you want to, or whatever. If that's within the past 5 years of you applying for choices, TennCare's not, they're going to say, you had $20,000 that you gave away. You could have used that to pay for your care. That would have paid for 5 months, or for 4 months in a nursing home. Yeah, at $5,000 paid for 4 months in a nursing home. So we're not going to pay for 4 months. You're eligible financially, you're eligible medically, everything's all set. You're probably already in the nursing home, but we're not going to pay for 4 months because of what you did. That's usually kind of a deterrent for the nursing homes to accept people if they know about anything like this. So try to not talk about it at the nursing home if you can. But there are some ways to get around the penalty period. Like we just said, give it back. If it really is a situation where the adult child, which is usually who it is, or the caretaker just didn't realize they do their homework, they don't want to cause any problems, they just want to get through with this however they can. Oftentimes they will just give it back, like this $3,000 situation. That's probably the easiest way to go about it. The other way is a hardship waiver. The hardship waiver really is a hardship to complete. It requires lots and lots of paperwork. You have to demonstrate life or health would be in danger without the service, or that you would be denied necessities, food, shelter, electricity. Those are usually pretty easy burden. It's the paperwork burden that's so tricky. You have to get something signed from the director of nursing. You have to get something signed from the doctor. You have to get, I had a client who his wife had a brain tumor and he had Alzheimer's. They didn't realize she had the brain tumor, which was affecting her behavior. Between the two of them, it's a perfect storm. They basically ruined their house with hoarding, animal hoarding, stuff like that. So the son comes in, he gets them both in institutional settings where they're safe, and then he goes and basically has to gut the house and sell it for whatever he can get. TennCare said, well, the tax assessor said that this house was worth this much. And he was like, no, you don't have any idea. You don't know what they did to this house. So the paperwork burden for that case was incredible. And it was just, they had to get so much from, like you said, the real estate agents and the contractors and the receipts. And he wasn't really even thinking about it very well. Or he wasn't beforehand. He was just in survival mode. He was just getting everything where it had to go. But it certainly felt like a hardship to me as well because it was so horrible. Yeah, and then the last one showed that
I was going to say, when it says the applicant must demonstrate life and health will be in danger, if it's an individual, like just a single parent, but there's no POA or anything, I mean, does TennCare say, well, child, you take care of that parent, or you can just say, hey, I'm not taking care of them. They can't take care of them on their own. You see what I'm saying?
no.
I mean, because sometimes they'll say you have a responsibility to a parent or something. and you legally don't. I mean, morally you may have one. So
Yeah.
could you just say, I'm not doing it? I mean, it's hard to say that and meet that waiver maybe.
Right, right, that they would,
I'm not gonna bring them
You're
in.
saying
they're
that
gonna be
natural
homeless,
support.
You know,
yeah.
morally I should do that, but I couldn't meet that burden. Or what
I-
do you say?
I think the rules more say that it wouldn't, I don't think that they count that. I think that they're more looking for a doctor or a nursing home saying, yes, they really need to be here. I don't think this really serves any purpose. You're not proving anything that you wouldn't prove in a PAE. I think it's just to deter people from using it. Because it doesn't, I don't understand what, you're not showing them anything extra, you just have to show it different ways. Yeah. Estate recovery. Estate recovery I've talked about to probably a lot of you before. It's really not ever something that we deal with a client usually, just because they don't usually either own their own home, or they don't usually have a lot of equity in their home, or anything like that, or they fit into one of the exceptions that we'll talk about. The reason that estate recovery is makes me so mad is because people will call in and they'll say, I need choices, or mom needs choices. She won't apply because she says it's going to make her drug addict kid homeless who lives with her, or her grandchildren live with her, and they're going to take their house. So it's really reluctance to apply based on estate recovery. TennCare has the responsibility to inform people about estate recovery, but they do so in a way that I think borders on scare tactics. I don't think it's awesome. But so here it is, it's federal law requirement. Basically, when the enrollee dies, the general rule is that TennCare has the right to recover their costs. And usually based on all the asset exemptions, that means the house, because that's one of the only valuable things left to most people. So yeah, like I said, TennCare tries to force the sale of their home and take some or all of the proceeds. Estate recovery is complicated, has many exceptions. I have a client right now who, she has maybe $10,000 in her house. It's run down and it's in a very impoverished area. There's no way TennCare is going to pay lawyers to go into probate court and get this house from her, but she will not apply for choices because she doesn't want to have her house done. The reach of estate recovery, it applies to people who were on choices and who were 55 or older when they died. So for younger disabled people, estate recovery is not even on the table, just as a threshold matter. So for now, and these rules could always change, TennCare only intervenes in probate. So anything that would pass outside of probate doesn't count. But like I say down here, just because the rule was only for probate when you did your estate planning doesn't mean it's going to be the rule when you die. And what the rule that's applicable is the rule when you die. So what was something I wanted to go say? Oh, okay. So the tricky thing about this is that in probate, there's a 1-year statute of limitations for all these things. And it's a 1-year statute of limitations from the date of death, not the date that probate is open. So for these delays, if you can delay more than a year, there's an opportunity that you've avoided estate recovery altogether. So let's walk through these. So TennCare has to wait to recover the estate if the person has a spouse who's still alive. So you're not going to die and make your spouse homeless. A minor child, not going to die, make your minor child homeless. And that's, Tennessee law says 18, I think federal law says, no, it's backwards. Federal law says 18, Tennessee law says 21. Who knows what they would do? Permanently disabled child, or a sibling who co-owns a house. So in any of these cases, you would have to wait for that operative person to die before TennCare could take the estate. If the question is, if one of these people survive the decedent for a year or longer, would TennCare be able to intervene in probate? I don't know the answer to that. I don't think it's been litigated, but it would be a fun one. And then these are the, yeah, go ahead.
So that was a case, and I do not know the name right now, but I do know there was a case that came out maybe last year that says that the 1-year statute of limitations for creditors don't apply to.
Does apply to TennCare?
Yeah.
Awesome.
Yeah, I know.
Okay.
Broke all of our hearts, but there's not been any other litigation, I think, since then.
Okay.
But it went through all of this about why, basically, as usual, the government is exempt.
Sure. Well, that must be judge made law because there wasn't any statutory authority that I found.
No, that's not. So
Interesting.
I'm hoping maybe that changes later.
Yeah, hopefully.
There is a statute that excludes any state agency from any statute of limitations.
That would do it.
Say again.
There's a statute, Chris and I were working on a case involving collection of court costs that were 30 years old. And there is a statute that exempts state agencies from any statute of limitations. There is a Latin term that I can't remember, but basically, time does not run against the stop. So that may be where we can.
Okay, well, these are the actual exemptions. So they can never recover on the estate if there's an undue hardship. Undue hardship is defined in 3 ways. Family farm, family business is the first one. It's the only way that a family member can make money. And then these last 2 are the ones that I use most regularly. A sibling's care kept the person out of a nursing facility for 1 year and the sibling still lives in the house. So this is brother's sick and they're living in brother's house. Sister moves in with him. She takes care of him for 1 year and you get a doctor to say that without her care, he would have had to go to the nursing home early, a year early. For clients who are nervous about this, there's a form that you can fill out and it's supposed to be after death. But we've before have filled them out and said, this is the exception. This exception, interestingly, is not listed on that form. None of these 3 hardship exceptions are listed on the form. It's only the delays. It's only these that are listed on the form. So we fashioned our own page 3, including these 3, and sent it to the client. And she got her doctor to say all the things that she needed the doctor to say, just went ahead and did on the front end. She was really worried about estate recovery. And then the last one, similar to the second one, child's care kept the person out of a nursing facility for 2 years and the child still lives in the house. So, yeah.
So I've had to do a fair amount of research recently on the child caretaker exception, specifically on what level of care meets the standard.
Wow.
You know, like in other words, is it just being present, helping you day to day, you know, is it can it be loosey-goosey like that, or does it have to be quit my job, I did nothing but, you know, drive mom around, do appointments. I had no life of my own, you know, I was a complete 24/7 caretaker. Tennessee, unsurprisingly, has no law on this, apparently. There are just a couple of states that have litigated, and they've gone opposite directions. One is very extreme, you know, you give up your life, you're living. The other is, you know, you can still have like a side job, you know, much more reasonable. I'm just curious if you all have heard or dealt with or.
I've never had one after the person's already dead. Just like I said, because most of our clients don't have, if they do own their own home, it's not usually a very valuable home or they don't have a lot of equity in it. So this is never, I don't even think I've ever had a client where TennCare has actually gone after the property. It's mostly people being worried about it on the front end. So I don't know, but that's interesting.
I had a client earlier this year that had that situation. We applied for the child under hardship. Teachers this with information. They wanted a lot of financial information from that client. 5 years of tax returns, car registration, things like that. But all we had to do for the medical, I had to get a doctor to sign a form saying that your care of mothers for 2 years.
That's the advice.
So
yeah, that's the advice I've always given. Is,
yeah.
You know, if the doctor says so, it should be good enough.
Yeah.
But you know, at least in other states, there's been some pushback on that, where they really want to get into the details of what caregiving has been offered or provided.
And who knows how many years later that would be.
Sure. Right.
Crazy. All right, I'm gonna have to pick up the pace a little bit. Oh, wait, perfect timing. Right, this is you?
Yep.
Great.
Hey, so just real quick, so can you avoid the recovery if they don't go through probate?
Yes, question mark?
Okay.
Yes, but they can force probate.
Oh, they can, okay, that was my question.
And the other thing is, if you try and sell a house and you don't have a release from TennCare, you're not gonna be able to sell it.
So they can put a lien on that.
So,
yeah,
the children of dear departed can't just not probate and sell a house.
That's like it just go to probate.
Yeah.
Okay, this is going to be a little more freeform, and feel free to jump in, add things here. talking about, got a client who's appealed. What do you do? If the client doesn't get a 9 on the PAE, what are you going to do? Obviously, it's an appealable issue. First of all, like I mentioned earlier, ADLs and deficiencies with ADLs, the rules say these have to be tied to something specific in the medical records. My experience is that the ALJs are pretty loose about this, as long as you can kind of arguably say, look, this is reflected generally in the medical records. There's a condition that would explain this that has medical documentation for it. TennCare's position is that the records have to say explicitly what the ADL deficiencies are and how often assistance is needed. It's what their attorneys have argued. The ALJs haven't bought it, but it is helpful to get as much as you can directly from medical records, both for ADL deficiencies and for safety issues. The big thing that we see all through medical records often is fall risk, which can be helpful because that's one of the things that they're really looking for in a safety determination. Is this person going to fall and break a hip and cost us a lot of money? When you get the hearing pack in a PAE appeal, the documents that are actually in there, and there'll be a lot of medical records and other things, but you will have a level of care form, which is their sort of clicking, here's all the boxes and here's the scores that we gave and here's why. Along with some, what look like primary sources, they're both the applicant interview and what's called the collateral interview. These are on appeal. They send Ascend, which is their contractor that does the second level. Once a PAE is appealed, Ascend then looks at the PAE and rescores it. So there's a collateral interview. They interview both the applicant and the collateral person. So that could be a caregiver, somebody who lives with them. And they do this often at the PAE and at the appeal level. I have rarely seen any where they're consistent between them. I mean, the inconsistencies in both the appeal and the thing to ask on appeal when you're cross-examining their witnesses is, why did you pick the almost, or what's the most of the time rather than some, what is it? Usually or
Usually not.
Usually or usually not. Yeah. Why did you pick usually over usually not when one interview says more than 4 days a week, one says less than 4 days a week? They usually don't really have a good answer for it. It is pretty ad hoc in the way they put these together, and they just get a general sense and know they give them the scores. Looking at those inconsistencies, really leave them kind of dumbstruck. They don't know how to respond to the questions. And at the same time, these are collateral interviews, and often the person who's going to be testifying for TennCare is someone from Ascend, someone who has conducted none of the interviews on their own. So many of the documents are hearsay within hearsay. I would freely use your hearsay if it's helpful to you. If there's a document you really want to exclude, like, I've got a client who's just kind of a crotchety guy. The nurses clearly don't like him in the collateral interview. There was a lot of negative stuff about, he could if he wants to. He just like changing his ostomy bag. They're like, he could do it. He just, every time we come in the room, he's like, it's your job, which, he's not wrong, but
tell him about his physical condition.
Well, he has a non-functional birth defect, a non-functional arm, and they say he can change his ostomy bag by himself, which is, I guess, surely physically possible, but probably risky at the very least as far as what you're going to spill. So those hearsay objections are really important there. I think you can keep a lot of stuff out. It's often, a good idea. Some of it you're going to want in, but TennCare attorneys, in my experience, often get very flustered once you start throwing objections around. So things can heat up fast that way. And then look to see if a safety determination was requested. Let's say they got a 4, and you really don't see how you're going to get them up to a 9 on that. See if there's a safety determination requested. If not, use that rule about, it's 42, I have a number in my notes. I think I did. Yeah, 42 CFR 435.905. This is that the agency must inform applicants of their rights and responsibilities and all the eligibility criteria for the program. And they have to do that on paper and electronically. They clearly don't do this at all, but they definitely don't even tell anybody about the safety determination. So I would definitely use that. Across the board, the very best thing that you're going to find to have with you is a doctor who will testify. So getting a doctor who's going to stand by their client, by their recommendation about what the needs of this client are is going to be the very best thing you can get. I have often, not so much in the PAE appeals, but in medical necessity appeals, which we'll talk about in a second. And in fact, let me just wait and get there. In medical necessity appeals, where a doctor has said, my client needs X, and TennCare says, no, you don't. The MCO turns them down. You get denied. Doctors, you can't subpoena a doctor to a hearing in Tennessee. You want to get them to participate. One thing that I found effective is, doctor, I know you're really busy, but there's this other doctor who's never seen your patient, who just looked at some medical records. They work up in Minnesota somewhere. They don't even work in the state. And they said, you don't know what you're talking about when you said this. Doctors, their ego gets a little damaged when another doctor saying that you just don't know what you're talking about. You're wrong. So can sometimes be helpful to persuade a doctor. But the other thing, if you cannot get a doctor to the hearing, there is, in the Uniform Administrative Procedures Act, there is this rule, and this is a quote that you have to put in a letter with a declaration from the doctor. If you can get the doctor to do a declaration, and first of all, in Tennessee, declarations and affidavits are the same. You don't have to have them notarized. 10 days prior to the hearing, you get this declaration from the doctor saying what their testimony is going to be. Send a cover letter with this exact language. This is in the rule. Says this affidavit is going to be introduced into evidence. If you want to cross-examine this person, you have to let me know within 7 days. If not, this affidavit or declaration shall be given the same effect as if the affiant had testified orally. So this is the way, if you really want to get that doctor's statement in, but you're not going to have them testify. I have never had a TennCare attorney respond to one of these.
I have.
You have. I know Lenny said he had one too, and
Me too.
that got litigated into who had to pay for the deposition.
Dave Kozlowski.
Oh, was it Dave?
Lenny had that, but Dave Kozlowski did before, and we had a dental case. No, it was a child gastro thing that they were like, and we're going to do a deposition. We used Dave Kozlowski's case that said, TennCare, you pay for it. And so they were like, whoop, never mind, we don't want to do it.
Order from an administrative judge that said, particularly because a doctor can't be subpoenaed. You want to do a deposition of the doctor, TennCare, you pay for it.
Yeah, so this is, recently, has that happened anytime recently? Or is it?
New attorneys will try it. That's the ones that kind of know their stuff will not even bother with it. It's a new attorney. It's like, you're like, what? And I whip out Dave's case, and then they're like, okay, never mind. And we have a copy of Dave's case just in case anybody wants it. So
Maybe you can circulate it to the health and benefits. Okay, so let's move slightly beyond eligibility and say you get a plan of care and the services there are not enough. Client says, I need more, it's group 2, I need more attended care hours, I need this or that. And this is not on we're not talking above service limits. There are limits built into a lot of these, but we're saying just on the medical necessity ground.
Danielle's going to cover this, remember?
On medical necessity?
No, but that's next.
Okay, yes, but medical necessities after that.
Great.
Some of this we did and we were preparing slides separately. So Danielle is going to go next. I'm going to skip some of these slides because it's going to be in hers and we also don't have time for them anyway. So yeah, there we are. The plan of care itself can be appealed. They should be telling people this at the time that the plan of care is developed. Should say, if you don't agree, what actually happens sometimes is people say, if you don't agree to this, you're not going to get choices. So you have to sign this. That's not true. What's in that plan of care, you can appeal and say, I need more hours than that. And then it just goes to the standard, the regular medical necessity standard in TennCare, where you have to prove it meets the standard. Now, this is, again, back to the sort of broader TennCare thing. This applies across the board in TennCare. But Tennessee's medical necessity standard, when it was put in place, Kaiser Commission on Medicaid and Uninsured did a study, found that our current medical necessity standard is substantially more restrictive than those used in other state Medicaid agencies, Medicare, federal employee health benefits, and private sector plans. We have the strictest definition of medical necessity in the country. And so we always have to overcome that issue. But it's a 5-prong test. And on the two that you would deal with in a choices situation are safe and effective and least costly alternative. It depends on how they frame it. But safe and effective, I'm only going to run through a couple of these. People get a notice and say, you don't get this because it's not safe and effective. And they're talking about home health aid services. And it makes no sense to people why something like hours of home health service would be cut because they're not safe and effective. What could it possibly mean for it not to be safe and effective? Well, the rule says it must not be in excess of the enrollee's needs. And that's what they're relying on when they say it's not safe and effective. It's you're getting more than you need. So it's not effective to get that many hours. We can give you less. And then there's the least costly adequate alternative, where TennCare can deny a service if they say there's this other service that's adequate, or that you can do it for less, and that's adequate. Of course, there's always the question of who decides what's adequate. And in fact, the way the rule is written, if you're doing a med mal case, let's say you're a private attorney, you're doing a med mal case, and your defense was, it was adequate. My doctor provided adequate care. That's not the standard. The standard of care in the community is the standard there. So you could technically have a situation where TennCare denies a service that would avoid malpractice and will only approve the service that could get the doctor sued for malpractice because they're using adequacy, not the standard of care. Now, of course, most of these choices issues are not going to be like this, but always use all of those tricks, getting the doctor to testify, getting the affidavit to show medical necessity for the plan of care, how much people need. And last of all, Danielle's going to cover some of this, I think, but if someone is on choices and they have approved home health aid services, private duty nursing, anything like that in their home, and the nurses don't show up, or the home health aides don't show up, happens all the time, appeal it. Please, please appeal it. The comptroller right now is doing a top to bottom performance audit of TennCare and has specifically asked us to send them all the cases that we can find of them not showing up, because we've been telling people to appeal this for a long time, and we knew clients who had appealed dozens of times. The comptroller asked TennCare for all appeals that involved a missed shift, and they gave them a total of 8 cases, which has to be wrong. There's no way that's right, because we've had
huge in rural communities. And what happens is, what they'll say is client denied, or somehow they won't mark it in the notes, because we've had these on cases, and yet if you look at the nursing notes, they never say, oops, nursing didn't show up, but they have some other thing in the notes. And you talk to the client, she's like, well, nobody showed up, or they sent me someone that had no idea how to handle my client. And I said, no, so the client refused. But if they didn't have an appropriate one. So in rural communities, it's huge.
Yeah, and Danielle's going to talk more about this issue, but the comptroller in their audit of both BID and their general HCBS audit used the word caregiver crisis. that we have a very serious problem filling these, especially in rural communities.
So we need to send those to you.
And it's going to get, I hope Danielle scares the Jesus out of you, because it's going to get a lot worse.
But we send those stories to you when we see them?
Yeah,
Okay.
I'd love any time there. I mean, we are actively collecting, and all this caregiver crisis is really, we're pushing to the front burner of what we're doing at TJC. So things like missed shifts, or let's say somebody gets approved and they say, yeah, oh, you just got approved. It's June. We hope you'll have services by September, which also happens all the time. They just say, we can't get anybody right now.
Or, you know, this is what you really need, but we don't have enough, so what if we just give you this instead? Like, oh, that sounds great.
Yeah.
But
Yeah,
it's
often that's in the care planning, that's what they do.
Okay.
And you know, it's gonna be too hard to deal with that, so how about you just take something
They're just
less?
grateful for anything.
Yeah.
Okay.
Just always remember, please appeal those and let us know, because we really want to track this. So that's missed shifts, consistently late shifts, or, you know, people who, you know, poor quality caregiving that is not on the technical side. It's not that they don't know how to do it, but that they're always on the phone outside, showing up late, leaving early.
One I hear about is they're not able to lift, not able to help with transfers.
Right, which is for some of them, that's the whole reason they're there, and they can't do it. And the inability to find an agency to do it. We often run into cases where families get blackballed by agencies.
Yeah.
The agencies just say, we're not working with them anymore. So we're trying to find solutions to these whole bunch of problems. I won't steal Danielle's thunder with more caregiver stuff, but please do let us know. So we're about 8 minutes. Let's open it up to general questions. Anything about
I have a funny questions slide.
funny questions?
Yeah.
No.
You can go to the next one now.
Yes.
So one thing Rachel and I have both run into is, you know, if they have the date of the PAE, let's say it's like April 1st, TennCare will argue the issue in the hearing is, did TennCare know as of April 1st that this person was eligible? And so let's say even if we, as we're prepping for the case, find some really great records like May, or even some records before April that TennCare didn't have access to, they will argue that we cannot submit those records at the hearing because it's considered new evidence. And the issue at the hearing is not whether they're eligible for choices. The issue at the hearing is whether TennCare made the correct determination on that particular day with the information they had. So I was wondering what approaches, if you've seen that, what approaches you've taken to that argument.
My approach is my client bears the burden of proving their eligibility when they apply. It doesn't matter if they check the wrong box. It doesn't matter who. It's TennCare's job to get the medical records. It's not my client's job to do that. The question is not whether you made a mistake based on the information before you. It's whether the client is eligible or not.
And TennCare's in an advantage there because they write in their very fancy notice of hearing what their statement of the issue, and there's no real opportunity to respond with your own statement of the issue. I lost this fight.
Quickly.
I lost this fight 2 weeks ago in my hearing. She wouldn't hear. We didn't even allege a change in condition. We just alleged that there are 8 falls since last September, or 8 hospitalizations and 2 falls. There was no change in condition. The PAE happened right smack dab in the middle of it. The later evidence just further establishes the pattern. She wouldn't hear any evidence.
But I mean, there's multiple ways that
Rachel Waterhouse.
I mean, there's in that situation where there's actual evidence that happened after the application date, I think you're arguing relevance there. Other stuff, so for example, I had one where they denied someone because on her, this is slightly different, but it was a renewal packet on the for choices 3. And on the renewal packet it said, do you need institutional care, nursing home care, or nursing home level of care? And she clicked no. And they said, and their position, TennCare's position was, we got it right. Even though she was on choices 3, she did need it. She was still eligible. Nothing had changed. They said, we got it right because she checked the wrong box. No, the issue, that's why we have a hearing process. She has the opportunity to prove she's eligible. And
so anything
before, you can use, but if it's anything after, then it's probably you need to submit a new application.
Or, I mean, I would still argue relevance in there. I think in Shelby's case, I think the judge was wrong. I mean, I think it's relevant to a safety determination that she kept falling.
She keeps falling
even
down.
after applying.
She fell before and
Definitely
she fell
anything
later.
before they have to use, they can't exclude it. If it's there, it's out there in the world of
I mean, a judge, I don't think so. The judge may disagree.
On the issue of relevance with new medical evidence, the argument that I made that was successful in my hearing like 8 months ago was that it was not based on a new diagnosis, it was based on the same diagnosis, and there was no evidence that there was a change in condition. So all of that information related back to the previously established diagnoses. So the judge bought that argument.
Yeah, I think that is similar to what Shelby had, and the judge didn't buy it in that case.
Is that Hamby? Was that Hamby? Didn't Lenny argue a case on Hamby? Do you remember Hamby?
Well, we've certainly gotten decisions about new evidence, and the Department of Human Services literally has a policy recognizing that at least if the evidence relates back to the time of the decision, it's admissible, even if it didn't exist then, even if the department didn't know about it. But there's mixed case law, but the majority of state decisions hold that new evidence is admissible. And the APA talks about only considering evidence presented at the hearing. That doesn't make much sense if the only evidence that's relevant is whatever was in TennCare's hands 3 months earlier.
The problem just that I've run into also is that with the collateral interviews, it's most likely the current home health, if it's a renewal choice situation, if they're current home health workers, and like you pointed out, some of them hate our clients because of various reasons. But another thing is if the home health worker only comes 3 days a week, and they'll say, well, I help her physically walk every day I'm here, then they mark the box 1 to 3 days because the home health worker's there only 3 days. And so I've argued that, and so that was a situation where they changed home health system, or home health providers like during the appeal. And so I got the new home health records to show that the home health workers were they were going more often, but like less hours in a day. And so to show, like, look, if they're doing it every day they're there, and she really needs this every day, she needs somebody every day. But he wouldn't buy that argument, and he would just ignore the new evidence and said that there was a change in condition.
I've got the reverse situation, which is in the collateral interview of a home health provider who had only seen the client 2 days. Said, oh, she can do that every time. I was like, well, you only know that you can do it 2 days. I've got the hearings next week. So, and they're saying they're sticking with that story that somebody who saw the client on 2 different days, when their own rules contemplate, maybe someone can still usually needs help, even if they don't need help 2 days.
So did you win your case, Emma?
Well, we lost, but for another reason. The judge didn't really rule on that issue. He just took it under advisement, but then didn't issue ruling on it.
Anything else? Thank you, everybody.
Hey guys, we have more toolkits right here. We aren't sure if everybody got one. They're right here. Thank you.